Just doing a quick test.
Yes, I can hear you.
Thanks so much. Just testing my microphone. Stephanie, can you hear me?
It's Casey, and yes, I can hear you.
Hi, Casey. Thank you. All right. Good afternoon. Before I officially call our hearing, I just want to check in with my court reporter. Tracy, are you ready to go?
Good afternoon, Judge. I'm ready.
Okay, thank you. Now calling proceeding number 23A-0356E. My name is Melody Mirbaba. I am the administrative law judge who was assigned to this matter. We are set for a pre-hearing conference pursuant to decision number R23-0582-I. I'll just remind everybody that consistent with commission practice, we are webcasting this proceeding. That includes all the video and the audio. And if for some reason we take a break during our hearing, the webcast will continue. So please do keep that in mind. Let's get started with entries of appearances. And I'd like to start with Public Service Company of Colorado.
Good afternoon, Your Honor. Stephen H. Denman, Assistant General Counsel on behalf of Public Service Company of Colorado.
Thank you, Mr. Denman. On behalf of the Commission trial staff.
Good afternoon, Your Honor. Brian Krakis, Senior Assistant Attorney General on behalf of trial staff of the Commission.
Thank you. On behalf of the Colorado Energy Consumers, who I will refer to as CEC.
Good afternoon, Your Honor. Michelle King of the law firm Holland and Hart. I'm here on behalf of the Colorado Energy Consumers, and I'd also like to enter the appearance of Austin Jensen, who will be participating with me in this proceeding.
Thank you. And you know, you're going to need to have him do a written filing if he wants to get service.
If I may respond, ironically, he is getting service and I am not. But both of us are listed on the intervention, and one of CEC's representatives, Mike Kornblatt, has been receiving emails, and I think that there was a mix-up just in our initials, MK being so similar. And so would Your Honor prefer that I make a formal request to be added, or is our intervention sufficient for that?
No, that's fine. If you're on there, if you're having some technical problem, I would suggest you reach out to one of our technical specialists that can make sure that that gets cleared up on that. Okay.
Thank
And
you, Your Honor.
for the city of Boulder.
Hello, Lucas Markley, Assistant City Attorney for the City of Boulder.
Right. For the city and county of Denver.
Good afternoon, Your Honor. Amanda MacDonald, Assistant City Attorney for the City and County of Denver.
Thank you. For Energy Outreach Colorado, who I will refer to as EOC.
Good afternoon, Your Honor. Gabriela Stockmeyer of the law firm Dietz and Davis on behalf of Energy Outreach Colorado.
And for the Utility Consumer Advocate, who I'll refer to as the UCA.
Good afternoon, Kate Crampton with the Attorney General's Office representing the UCA. I would also enter the appearance of Patrick Wittershine. He is also present on the Zoom call and I believe is listed on the intervention as well.
Okay. And again, I'll just let everybody know that if for some reason you're not getting all the attorneys that need to be served are not getting served, please do reach out to our commission. We have specialists that can help get that cleaned up. I mean, that's an easy fix. So, all right. Thanks for everybody's entries. The first thing I want to do is address all the interventions. Staff has intervened of right. And so all there is to do with staff is just to acknowledge staff as a party. So that's what I'm doing. And turning to CEC, Boulder, Denver, and EOC and the UCA's late filed intervention. I'm going to grant those interventions, particularly given that there's been no objections. I'm treating them all as unopposed. I also just wanted to note in terms of the UCA's intervention being filed late, I don't see any prejudice. We haven't even set a schedule yet. So I just don't see any reason why that being late is a problem in our case. Okay, so with that, everybody that we have here is a party to our proceeding that will go in the written decision that I issue that comes out of this hearing. Before we turn to establishing a procedural schedule, I think we first need to I need to hear from the parties as to whether extraordinary circumstances exist that justify a 130-day extension of the statutory deadline for a final commission decision per Colorado Revised Statute 40-6-109.5, paragraph 4. I want to go ahead and start with hearing from public service on that. Mr. Denman.
Thank you, Your Honor. I must confess I've negotiated a lot of procedural schedules and said a few in another position I held. This has been the most difficult procedural schedule to negotiate I've seen in many years, if not ever. The commission's calendar, as we know, is exceedingly busy. We internally prepared a list with a lot of dates in November all the way through January, and it's difficult to find 2 or 3 days to hold a hearing on. And the fact of the matter was we couldn't find any hearing until February, and then Your Honor was not available on the dates that council had agreed on. So largely due to the difficulties due to the commission's calendar and how busy things are, we believe extraordinary circumstances exist here that warrant your extending the 250-day deadline by an additional 130 days. Additionally, many of the parties in this case are also in other cases that are going to hearing in December and January. And given the fact that a lot of counsel is not available, we find that those are also extraordinary circumstances. And the schedule that we tendered to you today, and I sent you an email about 15 minutes before the hearing started, is intended to allow both your honor and the commission adequate time through the 130-day extension to fairly and timely reach a decision in this case. So we believe all the facts and circumstances here warrant the extension because it's clear that extraordinary circumstances do exist. If your honor would like testimony on this point, I have a witness, Mr. Jason Piquet, who is prepared to offer testimony explaining to you why he believes extraordinary circumstances exist. However, if your honor doesn't need testimony and my remarks are sufficient, we're happy not to present the witness.
At this time, I'm not sure that testimony is going to be necessary, but I did have a question for you, Mr. Denman. By any chance, do you know any of the proceeding numbers in which counsel and parties to this proceeding have hearings scheduled in the coming months?
One is the Public Service Company Phase 2 electric rate case. That's 23A-0356E. Evidentiary hearings in that case are scheduled on December 11th through December 15th and December 18th through December 19th. The Public Service Company Transportation Electrification Plan, the TEP case, is proceeding 23A-0242E. In that case, the parties also found it necessary to seek the 130-day extension and ask the commission to find extraordinary circumstances. And the hearing in that case is set for January 10th through January 24th of 2024. And in those cases, we ran into some of the same parties. I don't have a complete list of parties. I know staff in the UCA are in those cases. I'm not completely certain about everybody else. They can chime in if they wish. But those are all multi-party cases. And in fact, some of the same witnesses might have been involved. I'm not sure. Those are two that I know of.
Okay, I appreciate that level of detail. Before I comment, I just want to see if any other of the other parties would like to add to or respond to anything that Mr. Denman has said, and I'll start with trial staff.
Your Honor, the only thing I would add is a couple of other hearings that we have on the schedule. We have the Black Hills Distribution Service Plan. That's 23A-0357E. That has been scheduled for January 8th and 9th. So that's actually going to be back to back with the PSCO TEP hearing. And we are currently trying to schedule the Black Hills DSM SI hearing, which is, excuse me just a second, and I'll tell you the proceeding number for that. That is 23A-0361G. And it's looking like that is going to be on whatever dates we can find available in January, most likely the last week of January, although we have not yet given that to the ALJ presiding in the case.
And then Mr. Craighees, I don't know. I know for a fact that staff is on Black Hills Phase 1 and Phase 2 rate case, because that's my case, but I don't know if we have overlap in counsel on that one. Do you know?
I do not know whether my co-counsel is on that case. I know that I am not. Okay. I do suspect that we may have some overlapping witnesses.
Yeah, and I'll just note for the record, that case is 23AL 0231G, and it's set for 4-day hearing from November 28th to December 1st. Okay, and Mr. Kikes, do you have anything else you wanted to add?
No, other than to just second what Mr. Denman said regarding the finding of extraordinary circumstances. We would support that finding in this case.
Okay, thank you. And turning to CEC.
Thank you, Your Honor. I would simply add that CEC is also involved in the 2 public service company cases that Mr. Denman noted, as is counsel that's on this case.
Okay, thank you. And for the City of Boulder?
Nothing to add other than that we are also involved in the phase 2 rate case and the transportation electrification plan that were noted by Mr. Krakis.
And would the City of Boulder agree with Mr. Denman's assessment that extraordinary circumstances exist?
Yes, we would.
Yes, and I forgot to ask Ms. King that same question. Could you answer the same question for me on behalf of CEC?
Absolutely, and yes, we do. Thank you.
For the City and County of Denver.
Yes, the City and County of Denver are likewise parties in the phase 2 rate case and the TEP proceeding there's only 2 of us at the City and County for attorneys. So both of us are entered and overlapping witnesses as well. And we would likewise support Mr. Denman's request.
All right. And for EOC.
Thank you, Your Honor. Yes, we agree with Mr. Denman's assessment and the request for the extension based on extraordinary circumstances.
And then finally for the UCA.
Thank you, Your Honor. The UCA does support the request for a finding of extraordinary circumstances. As the court noted, we are party to the phase 2 electric rate case as well as the TEP. We are also parties to the Black Hills phase 1 and 2 rate case that you mentioned a moment ago. And both myself, Mr. Wittershine, and then Ms. Singer Nelson, who has joined the call, are all involved in that case as well.
All right, thank you.
Your Honor, before you go on, I left it out because it was on a different list. Proceeding 23A-0359E, which is a deferred accounting application being heard by Judge Adams. We were able to negotiate a hearing date of December 4th and 5th in that case, which took 2 of the dates that I had been looking at for this case. I appreciate remarks by counsel about only having a few lawyers. I'm the only attorney working on this QSP case at the moment. So it's been hard to find resources and hearing dates. I am supporting a couple of other cases, although I'm not lead counsel. So I appreciate the cooperation of all of my colleagues from the intervener parties and reviewing the matter of whether there are extraordinary circumstances here. And I certainly appreciate all their hard work in helping us get to the procedural schedule, which we will talk to you about in a few minutes, I'm sure.
All right, thank you, Mr. Denman and everybody else. I will say that, generally, I don't think that this statutory provision was, created for the purpose of, hey, we're all just too busy, to use that as extraordinary circumstances. I'm not really sure that's what the statutory provision was created for. It was really created for truly extraordinary circumstances. However, I have to say, I think that the level and the volume that the commission and all of the parties are dealing with really does reach that level of extraordinary circumstances. Now, I wanted to make it clear that I certainly wouldn't make such a finding if things weren't truly extraordinary when it came down to what everybody is facing in the coming months. And I face the same thing. I'm in the same boat as all of you. I've got tons and tons of hearings from now until the end of the year, and then tons and tons of decisions that have to get issued very quickly thereafter. So I feel your pain as well. And I do find that there are extraordinary circumstances that justify 130-day extension, and I am going to extend the deadline by that amount. All right. So with that done, let's talk schedule. And Mr. Denman, I did get that email. You said, I think, let me look at those dates. I'll just say generally, I'm not really a huge fan of bifurcating hearings like have been suggested. I believe you suggested March, couple of days, mid-March, and then maybe a couple days at the end of March. I guess one of my first question is, do we really think this is going to be a 3-day hearing? Do we really need that much time? This is a QSP. It's not a rate case. These tend to not be quite as complex. So really 3 days? I mean, that's my first question.
Well, Your Honor, I am not sure. My best guess is it would take 2 days to try this case. Others might want to weigh in. We know the amount of direct testimony and exhibits that Public Service Company filed. What we don't know is how many of the 6 interveners intend to file answer testimony, or how many witnesses they intend to present. And, it may be wise to pick 2 days and then have another date reserved. I too am not a big fan of bifurcating hearings. And I suppose as the party in a case like this who's filed the application, I just want to be sure that my case in chief gets in before the bifurcation occurs. So I appreciate your comment. However, it may be prudent to pick 2 hearing dates and then have a third as a reserve date. Other counsel certainly are welcome to offer either supporting or different opinions of mine.
Thank you. Mr. Markley, you've raised a hand. I appreciate using that feature. That really helps me know who to jump to next.
Yes, thank you. I might be the party who's mostly responsible for the suggestion of a bifurcated schedule. And the main reason for that is that each one of these weeks, at least one party has a spring break. So mine happens to be 2 elementary school kids with the week of March 18th. So my request would just to be to reduce the burden on any one party's spring break and split it up if possible, and have at least one of those hearing days the week of March 11th. So that's my basis for the request. So thank you.
Okay, I can understand that. And frankly, with the workload that everybody is facing and how busy we all are these days, I think everybody should take their spring breaks and enjoy them if you can. Take the time that you need, because things are not, I don't think, letting up anytime soon at the commission, especially for those of you who practice regularly in front of the commission. So here's the thing. I get that we don't want to push things too far out, but I really don't see what the urgency is in trying to fit it all in March. I mean, we could, let's look at some other dates. Let's see what else we have here. I mean, I think I would have plenty of time to issue a decision, well in advance, in advance of the commission's deadline, give the commission enough time if we were to hold the hearing end of March, early April, if we want to do 3 days. So let me go back to what was initially suggested, 26th and 28th. Let's see. I'm fine with both of those 2 dates. How about we pick a third date the following week? And I will clarify, I'm okay with erring on the side of caution and setting this for 3 days, if that's what the parties think is the best option. Mr. Fakes?
Your Honor, counsel for staff is on spring break the week of March 25th through, excuse me, I'm just looking at my calendar here. The week of March 25th through the next weekend, and counsel is actually going to be out of state during that time. So that was why we had moved it to the preceding weeks.
No, that was my fault. I have to put on my better glasses. I was looking at the wrong line. You guys had suggested 19th, 20th, or 21st. Are all three of those dates available for everybody?
And Your Honor, just speaking for Boulder, yeah, if we need to have 3 dates in a row to just to not bifurcate it, and the alternative is either do it the week of March 18th, or push it out to April, I think we would prefer to just have it the week of March 18th.
Okay. And your spring break is the week before, or the week of March 11th?
No, mine is that week, but
Oh, no.
I don't have plans to be anywhere in particular as of yet. So if it must go that week, then we will deal with that.
Would your preference be to give up your spring break and hold it then versus holding it the first week of April? I'm not trying to force people into giving up time with their families if we think we can still make this work.
You know, we just haven't discussed the April dates, I don't
Okay.
think, amongst ourselves. Yeah.
Let's talk about April dates. Let's see how feasible that is. The first week of April is wide open.
I'm checking, Your Honor.
Okay.
Your Honor, on behalf of staff, to the extent we do the first week of April, I would just ask that we start on the Tuesday or Wednesday rather than the Monday, since council may be returning that Sunday night late.
Sure. I can't say that I'm a huge fan of Monday hearings anyway. That would be fine. I'll just give you all a moment to look at your calendars if you need to. I am your clients and your witnesses. That's fine too.
Your Honor, I was able to check with my witnesses, and at least we are all available the first week of April.
Okay. And whoever has an answer, just unmute yourself when you're ready.
Your Honor, CEC, I'm checking with co-counsel, but I am available the first week of April, so we're prepared to proceed with those dates.
Great.
And Your Honor, I did just hear back from my client. The UCA can do the first week in April as well.
Great. And also I'm looking at the commission's calendar and there aren't right now any hearings set. So you all hopefully don't have any, at least you don't have any hearings around the commission that week. If you have, I don't assume that that's all the work you do, but at least not in front of the commission. I don't see anything.
And like you are, Your Honor, I don't like Monday hearings, especially given the fact that this Monday in April happens to be the first.
Yeah, April Fool's Day.
Not that I'm suspicious or superstitious or anything, but the second, third, and fourth, if you need to set 3 days, will work for public service.
Okay, so all I'm waiting on is Boulder, Denver, and the UCA and EOC.
Your Honor, I was trying to use the hand raise, but I'll jump in if that's okay.
Sure.
On behalf of Denver, myself and my co-counsel Chuck Solomon are both available, and our witnesses available as well. So
Great.
We are good.
And Your Honor, this is Kate Crampton on behalf of the UCA. I'm not sure if I was muted, but that first week of April does work for the UCA.
Oh, I'm sorry. I'm sorry. I think I wrote down, I didn't write down UCA, I wrote down staff.
No worries. Thank you.
Thank you.
Your Honor, I have not been able to confirm for Mr. Bennett, who would be our witness in this case, but I'm assuming it's fine, so we can go ahead and set it.
Okay.
First week of April.
And same for staff, Your Honor. I have not heard back yet from my witnesses, but I think since there's nothing else on the commission's calendar, we should be okay.
Okay. Great. All right. So let's go with April 2nd, 3rd, and 4th. Now, let's talk about whether we want to hold this hearing in person, remotely, or a combination of the two. I'll start with public service. What are your preferences?
One of my witnesses is from Minnesota, and either hybrid or remote works for us.
Okay. Does anybody else have a preference you'd like to express, Mr. Crakes?
Oh, I would just say staff's preferences remote here.
So I will take silence to mean nobody else has a preference. So Mr. Denman, you said hybrid or remote. If I'm not hearing a preference for people to want to come in person, I would tend to go with the remote option. So I want to kick it back to you one more time, because I don't hold a hybrid hearing unless somebody is showing up. I don't like to be the only one in the room.
I understand that, Your Honor. Give me a minute here, and I'm trying to communicate with my client. We actually said in person or hybrid early on in this case. We would show up if you said it for a hybrid hearing.
Okay, then it will be hybrid. Oh, Mr. Crakes, yes.
Well, Your Honor, staff does have concerns about ratepayers being charged travel expenses for witnesses coming in from Minnesota when a remote option is available.
I'm not sure that's what Mr. Denman was implying, but we can ask him. Or you weren't implying that your witnesses would fly in, because you mentioned you'd had a witness who would appear remotely, I think.
We have a witness in Minnesota, and frankly, Your Honor, I am shocked that staff is raising that issue in a case that's not a rate case. We haven't asked for any cost recovery of anything in this case, and there will be no adjudication of cost or cost recovery in this case, as far as I understand. And whether or not in the ordinary course of litigating cases in front of the commission, we incur some expenses, things like travel, meals, hotels, that stuff has never been disputed seriously. So I don't understand why on earth the staff is raising that question. You know, most of our people are in Denver, and you know, we have one witness who in a hybrid situation would perhaps appear remotely, but I don't know that right now.
If I may respond, Your Honor.
Yes.
The reason staff is raising this now is to try to get out ahead of the issue so we don't have to litigate it in a future rate case. You know, there are, as you know, myriad issues in rate cases, and we're trying to reduce the amount of money that ratepayers are asked to pick up on the tab. We would be happy to have a hybrid hearing as long as, you know, their witnesses from other states are appearing remotely, but we don't think ratepayers should be asked to pay for airfare and hotel expenses that at this point are purely optional.
Well, you know,
hold on, Mr. Denman. We can end this right now. Those issues aren't being decided here. I get your objection is duly noted. That is not for us. That is not for this case. And you can certainly, in a rate case, say you've brought up these issues. You can point to this case as an example, but you know, it's not going to be an issue that I'm going to really hear much more debate about. Mr. Denman, I'm going to just trust the company to make wise choices when it comes down to its witnesses. You've already mentioned your out-of-state witness at the onset that person would be appearing remotely. So we obviously need to have that remote option. Mr. Denman, you also said that because early on in the case, your client had expressed a preference for in-person or hybrid, that you would make sure that somebody would appear in person. That's enough as far as I'm concerned to hold this as a hybrid hearing. Ms. Crampton, did you have something to add? You used the raise a hand feature. So I just want to make sure you had an opportunity to speak.
Yes, thank you. Seeking clarification, when you indicate a hybrid hearing, are witnesses that are planning to testify remotely able to do so?
Yes, yes. I'll provide a little bit more background on what that really means. It basically means that anybody who wants to appear remotely can appear remotely. That includes counsel. Anybody who wants to appear in person can appear in person. The bare minimum is that at least one person, and I really expect at least an attorney to appear in person, because again, I'm not going to be in a courtroom downtown by myself. I want somebody else to be in the room with me. Otherwise, there is no need for it to be hybrid. It would just be fully remote. So Mr. Denman has made assurances that there will be at least him and maybe some witnesses in person. And I think, again, that's enough to keep that option open. In the deadline that we'll be establishing for the joint witness examination matrix, I'm going to include language in the decision that asks all the parties to indicate in which manner their witnesses are going to appear. I think that just helps us all prepare and have a better sense for what to expect when it comes time for the hearing. So we'll set this as a hybrid hearing. And Mr. Denman, I may also be setting a deadline to give public service, since at this point you're the only one that's indicated an interest in showing up in person. I will set a deadline if your client changes its mind later and wants to go fully remote. You could just make a filing by a deadline I give you, indicating as such, and in which case I'll just convert it to a remote hearing. We're going to set this up so that everything is presented electronically. So converting it to a remote hearing, if that's what happens later, is going to be seamless.
I understand, Your Honor. I appreciate your including that deadline in the procedural schedule. It's not likely that we will change our mind, but I appreciate the opportunity.
All right, thanks. Mr. Crickes, did you have something else to add?
Oh, just one other issue, Your Honor. Since we moved the hearing back a week, I'm wondering on behalf of staff whether we could move the proposed recommended decisions deadline from the 22nd of April to the 29th.
Yeah, we haven't, I mean, I got to go through all these dates right now. So let's go through all the dates.
Before you start, Your Honor, I might note that we had an original schedule that we proposed to you when we were suggesting hearing dates in February. And when you suggested hearing dates in March, I just tried to back off and go back from those dates in roughly the same time frames. There was no other magic to the dates that we proposed to you this morning.
Okay. And, from what I've seen, and I'll just say the dates that you're referring to, just for the record, were informally emailed to me this morning, and I'll go through them right now. But based on the hearing dates that were proposed, the first hearing date would have been about a week of March 12th, which is, let's see, it's like pretty much 3 weeks exactly before what we've now have for a hearing date. So maybe what we do is I look at the dates you've proposed, add 3 weeks to each one of those, and then that might be an easy way to come up with a schedule. So let me I've got a little tool that I use to do a calendar counter to do that. So the first deadline initially was proposed to be December 12th for answer testimony. Let me see what it would look like with 3 more weeks.
22nd, Your Honor.
Oh, thank you. December 22nd. All right, so I'm adding 21 days to that. That deadline would be January 12th, 2024. Okay. Any problem with that deadline?
I only note for the record that I will be out of the country that day, but on the other hand, I have clients who will begin reviewing that answer testimony, so that will work.
Okay. All right. The second deadline that was proposed was for rebuttal and cross answer testimony, and that was proposed for February 13th, 2024. Adding 21 days to that, we get to March 5th for that deadline. Any issues with that? All right, moving on to the pre-hearing motions deadline proposed was February 22nd. Adding 21 days to that would get us to March 14th. I'll just say, as a general practice, I like the pre-hearing motions deadline to come after all exhibits have been filed. Because I have seen in rare cases that, some exhibits filed later and then somebody wants to file pre-hearing motion about it. So why don't we come back to that, the pre-hearing motions deadline and get the other deadlines established first, and we can revisit that one.
Your Honor, I did have a question. You had in your list of events an exhibit and witness list. I thought I knew what you meant, and during our discussions, we just thought that might be the final notification to the commission of who are pre-filed witnesses and exhibits would be. Did you mean something different than that?
No, because generally speaking, in these kinds of cases, the testimony identifies the witness as written testimony, and it's already been filed far in advance. I add a deadline for non-testimonial exhibits because any exhibit a party intends to offer into evidence has to be disclosed, and it has to be pre-filed. And I don't like that happening all of a sudden at the time of hearing. So that is the additional exhibit deadline. And so basically the exhibit and witness list just summarizes everything and puts it in one document so that one can go and see, okay, this is all this party's exhibits. It just makes it easier for the record. And frankly, for me, when I go back and I'm looking at things, but the non-testimonial exhibit deadline is a little bit more significant than that, because it could be additional exhibits not already filed and disclosed. So maybe what we need to do is set that deadline right now. Let me see.
And before you set a deadline, Your Honor, may I inquire, by non-testimonial exhibits, you mean exhibits that are offered for purposes other than impeachment?
No. Because you do not have to pre-file exhibits that you may use for impeachment. The concept of impeachment is that you don't know if you're going to need to impeach until the witness does something on the stand or says something on the stand. Therefore, how could you possibly disclose that document? That's what the concept of impeachment is about. I'm talking about any other evidence that's not testimony or attached to testimony. Often that usually ends up being a discovery response that was served, say, after written testimony was filed, and therefore the party wants to offer it or may want to question a witness about a discovery response. That's usually what I end up seeing in all of these cases in terms of non-testimonial exhibits.
I thought that's what you meant. I appreciate the clarification. Thank you so much.
Yeah. And you also don't need to file exhibits that may be used to refresh recollection. It's the same sort of concept as impeachment material. You never know if you're going to need to impeach a witness until they've actually testified. Okay. So now that's cleared up. Let's look at a deadline for non-testimonial exhibits. And I want it to be before pre-hearing motions. And I'd like to give you all at least some time to do discovery after rebuttal and cross answer testimony before that deadline. So let me just see if I could do a little bit of math, but if anybody has a suggestion, feel free. Okay. If I make that deadline, hold on, I just got to pull up my discovery rules really quick, remind myself how much time you'll have.
For rebuttal, it's 7 business days.
Okay. All right, so I think maybe if we do 15 days from the date answer and cross answer testimony is filed, that should be enough time to get discovery and to file any additional exhibits. So that deadline would be March 20th. Unless anybody sees an issue with that, I am certainly open to hearing. All right, so the deadline for pre-hearing motions is going to have to be a pretty quick turnaround after that. I'm thinking March 25th, which is Monday, the Monday before hearing. And I'm sorry, I know that people will be on spring break, but you know, unless I have another 100 days, I'm not sure there's much more I can do.
Just to clarify, we would then have oral arguments on those motions at the outset.
I'm not certain that there's going to be much time between then and the hearing date to file a response. I was leaning towards March 29th being the deadline to file a response. That's about 5 days. And at least then I will see if there's anything, you know, I can at least have some preview of the arguments before the hearing. Because if it's a pre-hearing motion, I'm going to have to pretty much rule on it for the most part before the hearing gets started.
I mean, staff can, we can consent to a March 25th date for motions, but we are not going to be able to get a response filed by March 29th. So as long as there's an option to address them orally at the hearing, or if we could push the response date back a little bit. I mean, I'm going to be out of state. I think my co-counsel is tied up on vacation as well.
No, I need the responses in writing, so that's not going to be an option. I mean, I will allow people to add to whatever they've put in writing in a response at the time of the hearing, but I have to have something before the hearing before I rule. Otherwise, our hearing is, I might even need to take like a couple hours recess. It just depends on what the issue is.
So to be clear, it's a motion date of March 25th with a response 4 days later on March 29th.
Yeah, but you know, let me see if I can back up a little bit. I'm looking at the non-testimonial exhibit deadline. If we back that up to the 18th, that still should be enough time. There's not much wiggle room in terms of just receiving discovery, but it's doable, I think. Mr. Crakey, does that make a difference?
I think my clients are not going to be thrilled with a 7 business day turnaround between March 5th and March 18th in terms of getting discovery out. But at the same time, I just don't see it as possible for me to respond to a motion if it's filed on March 25th. So what would the motions date be if we push that back to March 18th?
The motions date would be the 21st.
Your Honor, I think for the sake of my clients, I'd rather just leave the exhibit date as March 20th, and to the extent there's a motion I need to respond to during that week when I'm gone, I guess I'll just write a brief while I'm on vacation. I don't know.
I'm really having a hard time hearing you. I don't know if it's your microphone.
I apologize. Can you hear me better now?
Yes, go ahead and repeat
Okay.
what you said.
I said, for the sake of my clients, I think, you know, they would rather have more time for discovery. So I think they would rather leave that date on March 20th for the exhibits. And then to the extent there is a motion filed on March 25th, I mean, just please note that both counsel for staff are going to be out of state that week, but I suppose you can set that deadline on March 29th.
All right. I'm going to leave it then. The non-testimony exhibit deadline, March 20th, pre-hearing motions, March 25th. Responses to pre-hearing motions will be March 29th. Might be time to reach out for additional attorney support at the AG's office, Mr. Frakes, for that week.
I'll take that under advisement. Thank you.
Yeah. I get it, you guys. I know everybody is really busy. There's just no perfect solution for any of this. Okay, so let's go back to our remaining deadlines. We've got settlement deadline originally proposed as February 29th. Adding 21 days to that, that would be March 21st. Only problem with that is that leaves just pretty much no time, very, very little time for settlement testimony before the hearing.
Yeah, and Your Honor, if I could make a suggestion, if you move the settlement deadline to the 14th and then have the settlement testimony at a comfortable time for you before the hearing. What I'd originally tried to do was leave enough time before the hearing so that you could go through the settlement testimony and determine any questions you had. So that was the idea. And I think if you moved the settlement deadline to the 14th and then had settlement testimony due, whatever date is comfortable for you, so that you've got enough time to look at settlement testimony before the hearing.
Yeah, I like that. I think the 14th would be fine, though. I'm actually, now that you mention it, leaning towards the 13th, because if I can align settlement testimony with the non-testimonial exhibit deadline, then that makes things cleaner and easier in the long run.
Sure.
So let's do a settlement deadline of March 13th. I'm moving, and then that way settlement testimony will also be due on March 20th. All right, now the exhibit and witness list. That'll be March 26th. The joint witness examination matrix will be March 28th. We'll set a March 25 deadline for a filing if nobody is going to appear in person, to let me know. Mr. Demon, that's going to be on you.
Yes, ma'am.
Then the proposed recommended decisions deadline. Let's see what you had. I'm going to make that April 18th. That's 2 weeks. I truly hope this is not going to be a 3-day hearing, but if it is, it is. I still think 2 weeks should be sufficient.
Your Honor, staff would request the 4 weeks that's in the schedule.
I was never going to give you that 4 weeks, Mr. Craigies. That was never on the table. But if you want a little bit more than what I'm, the 14th, go ahead and give me something reasonable. 4 weeks is not.
So, Your Honor, I believe you just said the 18th for that. Is that correct?
I said the 14th.
The 14th.
You know what?
is Sunday.
You're right. You're right. It is the 18th. I'm sorry. I wrote it down wrong. It is the 18th.
Could we move it to the 25th? Which is 1 week later.
I'll split the difference and give you till April 20th.
April 20th is a Saturday.
I apologize. I'm looking at the wrong month here. 22nd.
Thank you, Your Honor.
Do we have any agreements about discovery that we should put on the record?
The original agreement, Your Honor, was that Rule 1405 on discovery would apply. No one offered any changes during the negotiations on the procedural schedule, and we're fine with Rule 1405 and its various requirements.
Okay, I will just go ahead and run through the dates that I have written down because you never know, maybe I wrote something down incorrectly and you guys can catch me on this. So I've got for our hearing, April 2nd, 3rd, and 4th, hybrid. Answer testimony will be due on January 12th. Rebuttal and cross answer testimony will be due on March 5th. I will go ahead and say, you guys, if you really want more time in, that's the deadline where we could move things back if we move that deadline. I'll go through what we have, and if somebody wants to raise that, then we can try this again. But that's the one where there's potentially a little bit of wiggle room. So rebuttal and cross answer testimony, March 5th. Pre-hearing motions, March 25th. Settlement deadline, March 13th. Settlement testimony deadline, March 20th. Non-testimonial exhibits, March 20th. Responses to pre-hearing motions, March 29th. Exhibit and witness lists, March 26th. Joint witness examination matrix, March 28th. March 25th is a deadline to make a filing if no party will be appearing in person. And April 22nd is a deadline for proposed recommended decisions. Do we need to revisit any of this? Ms. King?
I would just make the suggestion that perhaps we move back rebuttal and cross answer to allow more time for settlement negotiations in advance of the March 13th deadline.
That's a pretty good point. Mr. Denman?
Let me count days here.
Sure. And since it is also the cross answer testimony deadline, if there are any other interveners that want to add your position on that, feel free.
Staff would second CEC's suggestion.
Yeah,
Okay.
Your Honor, at one point I had written down February 13th on the rebuttal. And did you mention that date at one point? Or is it March? You know, how far I can appreciate people wanting time to discuss possible settlement. We need enough time between answer testimony to do discovery and prepare the rebuttal. So
February
typically-
13th, Mr. Denman, was the deadline that you proposed in the email you sent me this morning. And it might be that you built in a little bit more time since that encompassed between answer testimony and rebuttal and cross answer testimony covered 2 holidays. So perhaps since we're not going to be dealing with holidays, you can go with a shorter turnaround on rebuttal and cross answer testimony.
You could move up the March 5th date by at least a week. You know, I'm not if settlement negotiations occur, they typically happen after answer testimony has been filed and before rebuttal. And maybe that's why we built more time in initially on the rebuttal deadline. So how much, if I could inquire, or ask Your Honor to inquire of counsel of what they had in mind to move up the rebuttal date.
And Ms. King, what do you think?
I think moving rebuttal back at least a week would be helpful. And part of the reason for that is while I appreciate that settlement negotiations can commence after answer testimony, sometimes what we have seen is that after the company files its rebuttal testimony, that then becomes the settlement offer. And so we want to have as much daylight between the rebuttal and settlement to avoid that potential. And so I appreciate the opportunity to move that back at least a week. So I think that puts us, what is that, February 28th?
That would be the 27th.
Okay.
Yeah.
Well, and Your Honor, sometimes it may be helpful to have 2 weeks between rebuttal and the settlement deadline. So settlement deadline is the 13th.
Yeah. I mean, that would be almost exactly 2 weeks. It would get filed on the 27th of April, and then settlement deadline is March 13th. I do want to give everybody a genuine opportunity to settle their disputes. You think 2 weeks will suffice?
The 27th is workable.
Okay. All right, then let's move rebuttal and cross answer testimony. That deadline is going to be February 27th. Now, Mr. Krakis, did you want to mention something?
I would just ask, since we moved that deadline, we revisit the motions and motion response deadline.
I'm happy to do that. I think we probably have to revisit a couple of other deadlines too.
I apologize, Your Honor. I did not at all hear what Mr. Krakis said. Perhaps others as well.
Yeah, go ahead and repeat that. You need
sorry,
to
I apologize. I just asked that since we've moved the rebuttal deadline, that we revisit the subsequent deadlines for motions and motion responses.
Okay.
I mean, in looking at this, because we're, the settlement deadline is the 13th and the settlement testimony deadline is the 20th. I mean, where's the wiggle room there? I don't really see the wiggle room in moving the motions. I mean, the other thing is I could just say, hey, you don't get to file pre-hearing motions that relate to non-testimonial or, exhibits that are filed after the pre-hearing motions deadline. I did that on purpose so that you guys all have the opportunity to raise objections to exhibits. So everything else would have to be moved, and I'm not sure that we actually added any wiggle room. What we added was more time to discuss settlement. Mr. Krakis, if you have a suggestion, let's hear it.
I'm looking at it now, Your Honor. I think we could buy at least a couple of days by moving the motions deadline back to March 22nd or even March 21st, so that it's one day after the exhibits deadline. And then leaving the responses to motions as it is.
Yeah, I'm not comfortable giving just one business day after exhibits are filed, but possibly the 22nd. Does anybody have any response to that? Because that means you look at your exhibit, you look at anything else that's been filed on the 20th, you draft your motions and you file them on the 22nd. Is that doable? It's tight.
That would be acceptable for the UCA.
Okay.
We could do it.
Okay. Anybody else? Take silence to mean you're fine with that. All right, pre-hearing motions are going to be the 22nd of March. And then let's look at the response deadline. What were you going to propose on that, Mr. Crakey? Is that we move that back to the 27th or
I
just
was
leave
going to
it?
propose we leave it as it is.
Leave it. Okay. That's fine. All right, so the two additional changes we just made are rebuttal and cross answer testimony will be due February 27th. Pre-hearing motions will be due on March 22nd. I think we've got all the deadlines that we need that I normally would set. It's entirely possible that as I draft my decision, I think of something else. And if I do, you guys are just going to have to deal with it. I don't think that there will be anything else. I don't. I think I've covered everything. I will establish procedures for the hearing as well and the written decision. Is there anything else that we should address while we are all together?
Your Honor, I can't think of anything. You've been very thorough.
All right, thank you. And I will just pause, and if you have anything else to raise, go ahead and do so. I will take silence to mean that nobody has any additional issue to raise. All right, with that, I want to thank you all for your patience and working through this. Sometimes this can be really challenging. I know that this is not necessarily the best schedule in the world, and you probably wanted something better, but I think this is probably the best that we can do under the circumstances. All right, so with that, I will go ahead and adjourn our hearing. Thank you.
Thank you, Your Honor.
Thank you.
you.